So, hello and welcome everyone. Today we are going to look at a decision from Germany, and decision of the Federal Court of Justice, the Bundesgerichtshof, which is the highest court in Germany. It is an important decision in the sense that it's not very often that the Federal Court of Justice decides a case with SEPs involved or front-related questions involved. Indeed, this was only the third time in which the Federal Court of Justice has delivered such a decision. The first two decisions were delivered back in 2020 in the so-called Siswell-Hire cases. And this is again the third time in which the Federal Court of Justice addressed these issues. The case is between HMD, which was the defendant initially in these proceedings, and VoiceAge, the patent owner, the claimant. You will, however, eventually find this decision to be cited also as Front Einwand 3. So it's what I have put in the brackets on the slide. This is the way the Federal Court of Justice has named this decision. It's Front Einwand in German. It means the front defense. And 3, it's exactly because there had been 2 decisions, as I mentioned before, in the past on the same topic. So just for you to keep that in mind, it could be that this decision is also cited in this way. Now, before we go into the details, let me just give you a brief overview of what the court talked about here, what was the focus point of the court. I think we can distinguish 3 major topics. The first one is the application of the Huawei versus ZTE framework of the Court of Justice of the EU. The Court of Justice of the EU has delivered a decision back in 2015 in which it has created specific duties for parties of SEP and front licensing negotiations. And this has been, of course, ever since fleshed out by the decisions of the national courts in the EU, including, of course, in Germany. And here, the Court of Justice, the Federal Court of Justice, provided some insights on how to deal with the Huawei ZTE framework, how basically this framework should operate, and how to look at specific duties under the Huawei ZTE framework, focusing on the willingness of the user of a patent that is a standard essential patent, and also on the obligation to provide sufficient security payment. So these are 2 major points which the court addressed. And another one, which is equally interesting, is the question of proportionality when it comes to the grant of injunctive relief for patents, also for standard essential patents in Germany, in Europe, and how this is linked to the Huawei versus ZTE framework. So that's what we're going to talk about today. But before going into the legal details, as always, let me give you a brief overview of the facts of the case. Here, of course, we're going to focus on the topics, on the facts that are relevant for understanding the decision. There has been much more story behind this dispute in the past as well. But let's focus on these proceedings and how they have been developed and how they have been going on for some years now. The action was filed back in October 2019. So there is 6.5 years before when this action was launched. It was VoiceAge that filed a lawsuit against HMD before the District Court of Munich in Germany, and almost at the same time made a license offer. What we need to say here about this first lawsuit is that it did not include initially claims for injunctions and for other exclusionary measures, for example, the recall and destruction of infringing products from the market. The first lawsuit, initially as it was filed, included particularly claims for damages. and associated claims, for example, claims for provision of information or rendering of accounts, etc. So just to keep that in mind, initially, the lawsuit did not include an injunction. After this lawsuit was filed and the offer was made, it took some time until HMD responded. It made a counteroffer in March 2020, and later on in May 2020, all of this during the proceedings, it also made a security deposit, which amounted to 10,000 euros at that time. Then the interesting development was in February 2021, so almost 1.5 years after the lawsuit was filed. The case was expanded by VoiceAge in the sense that VoiceAge added also claims for injunctive relief, the recall and destruction of infringing products in the proceedings. This is something to keep in mind here, because it played was discussed by the courts and also the Federal Court of Justice in this decision, that the claims for injunctive relief were added only later on. So the claims initially, the lawsuit initially did not include an injunction, but this was added almost 1.5 years ago after the lawsuit had been launched. The first instance decision was delivered in May 2022. The Munich District Court found in favor of VoiceAge and, among other remedies, granted an injunction against HMD. This case was appealed, so it moved now to the Higher District Court of Munich, which is the appeal court in this case here. And then the proceedings in the appeal stage started. And in this case here, we had an interesting development, because in April 2024, the European Commission intervened in the appeal proceedings by filing an amicus curiae brief suggesting a specific way of interpreting the Huawei versus ZTE framework, and also encouraging a referral of specific questions regarding these aspects to the Court of Justice of the EU. So this was something that does not happen very often in European case law, maybe in contrast to other jurisdictions, but this was a step that the Commission decided to take in the present proceedings and intervene in this sense in the appeal case between HMD and VoiceAge. Then shortly before the end of the appeal proceedings, again an interesting point, HMD raised the security payment. So initially it was 10,000 euros. There was some amount added at the end almost of the oral hearing in the appeal proceedings. At the end of the day, the decision came in the appeal stage in March 2025, and the Munich High District Court dismissed the appeal. So to a large extent, it confirmed the decision of the first instance court, including the injunction. There was a further appeal to the Federal Court of Justice, and this is the decision we are talking about today. It was delivered in January 2026, so in the beginning of this year. And by this decision, the Federal Court of Justice also dismissed the appeal. And so far, this decision cannot be, since this decision cannot be appealed any further, I think this is the last development in this case, at least, that we can expect. Now, let's take a look at the decision of the court in its merits. Of course, we had a decision of the court regarding the infringement question, but this is not so much relevant for our purposes here. We're going to focus on the front defense. And here, the court started with making some more general comments, or giving, let's say, some more general background of how this defense operates in infringement proceedings in Germany or in the EU, by highlighting here that as the case law has evolved, the front defense has a competition law background. So there is, the defense is basically based on a notion of a potential abuse of a market dominant position which means that an injunction or other exclusionary measures might be limited or might even be excluded if the patent owner, by filing a lawsuit and asking for this type of exclusionary measures, has abused a market dominant position in terms of EU competition law, more specifically in terms of Article 102 of the Treaty for the Functioning of the European Union, the TFEU. So the court said this is the background. This is a front defense under competition law, and this necessitates, of course, to ask two different questions. The first being, does the patent owner have a market dominant position? If you would say yes, then the second question is, was this market dominant position abused in the present case? Now, here in the HMD VoiceAge case, the court left the first question open. So whether VoiceAge, the patent owner, had a market dominant position was not decided by the court, because the court found that irrespective of whether this is the case, even if you would assume that there was a market dominant position, there was no abuse. So the court focused in its analysis more on the second question. So how do you answer this question, whether there has been an abuse of a market dominant position? The Federal Court of Justice said you need to have a comprehensive assessment and weighting of the affected interests, considering the purpose of Article 102 TFEU, which is to secure the freedom of competition. And what you need to do is to do this exercise always, this weighting of interests need always to be done on a case-by-case basis. What the court clarified here, and I say clarified because this was something that the court had also stressed in the previous decisions where it handled SEP-related matters, in the Sisvel Hire case, for example. The court said that an abuse in the sense that we're talking about here is possible only when in court you have claims asserted that can prevent standard compliant products from either entering or remaining in the market. This means that relevant for a potential abuse of a market dominance are claims for an injunction, because then you're being ordered to cease and desist of, for example, selling or importing products in a specific market, or remaining in the market, claims that could prevent products from remaining in the market, and this refers to the claims for the recall and the destruction of infringing products. Vice versa, and we're going to see that also later on, the front defense under competition law does not apply with respect to claims for damages, because these claims cannot really lead to an exclusion of products from the market. So this is a very fundamental aspect of the, let's say, scope of the front defense under competition law. Although, of course, the defense would apply to this type of claims that could lead to an exclusion from the market, the court highlighted, however, or clarified that the enforcement of standard essential patents, including through an injunction, is not per se prohibited. In this sense, the court followed the Huawei versus ZTE decision of the Court of Justice of the EU. The court mentioned here that IP rights, including patents, become subject of a market process, as the court put it here, only through the means available by the exclusivity right. So this means, in other words, that patent rights and IP in general becomes or gets a value by the fact that it can lead to the exclusion of the infringement from the market. And what is also very important when it comes to the question whether you should have availability of injunctions also for SEPs is that there are not other remedies available. Particularly, the court stressed here that the patent owner has no claim against the user for signing a license. This again means that enforcement also through an injunction remains or should remain possible. The court further explained here that the patent owner is not obliged to tolerate the unlicensed use of his patent. There is only one exception when this is the case, when this is required under its competition law duties, which is the duty not to abuse a market dominant position. But then again, the court said the duty to not abuse a dominant position requires, of course, that on the other side, you have an user that is willing to take a license on front terms. Now, looking at when an abuse can occur, if you have asserted rights that can lead to the exclusion of a market before a court, the court identified two scenarios. The one is a scenario where you have filed a lawsuit, including claims that could lead to the exclusion of products from the market, although the user has made an unconditional offer on terms that if you would not accept as a patent owner, you would violate the prohibition of abuse and discrimination. So if you have been made an unconditional offer on terms that you should have actually accepted, and nevertheless you file a lawsuit including claims that could lead to the exclusion of products from the market, then this could be potentially abusive. But this is not the only case. You can also have abuse occurring if the patent owner has not made a sufficient effort to allow a willing licensee to obtain a license on reasonable conditions. What both of these scenarios have in common is that in both cases, access to the invention is denied, or access to the invention is made subject to unreasonable conditions. So this is the common point. But what the court also highlighted here is that an abuse by a denial to give access to the patent on reasonable conditions is thinkable only when the patent owner does not depart from these unreasonable conditions or his refusal to offer access at the end of the negotiation process. And this is important because, as we're going to see further on, the notion that parties should negotiate and should negotiate in good faith is a very central one, and also very much highlighted by the Federal Court of Justice. Because the court said here, for example, that you need to have mutual willingness. It's of key importance because to reach an outcome, a license that can balance the conflicting interests of the parties, you need to have a negotiation process which allows the parties to articulate their interests. And this should be done from both sides, because what the court also noted here, the patent owner must, but also indeed only can, grant a license to a willing user. So this is basically a two-way street. You need to have an engagement from both sides. So that's what the court generally said about how the front defense under competition law works, and what is the background, what is the thinking behind that, what is the scope of this defense. And having said that, the court turned to the individual obligations that the Court of Justice of the EU has established in the Huawei versus ZTE case. As I mentioned in the beginning, the focus was placed on the willingness, and this is, let's say, the obligation that is placed on the implementer, on the user of a patent, to basically, if being informed of an infringement, then the implementer is required to express willingness to enter into a license agreement. But before that, there is, of course, the obligation of the patent owner to make a notification of infringement. So this is the very first obligation, and the court looked at that as well very briefly by highlighting here that this obligation exists because of this particular responsibility of the patent owner under a competition law to make clear that there is an infringement before asserting exclusionary claims before a court. So this is the first step, let's say the first duty that the patent owner needs to fulfill. In this context here, the court made an interesting clarification that this is basically the only duty that the patent owner needs to fulfill without looking at the behavior of the counterpart, of the user. Because the court said further duties means other duties above or beyond making a notification of infringement, and particularly a duty to make an offer, a license offer on front terms and conditions. These duties are triggered only and if the user has clearly articulated willingness to obtain a license and subsequently engaged in negotiations in a target-oriented manner. So again, the focus would be placed on the willingness here, and further duties or the extent of the further duties of the patent owner above the duty to make a notification of infringement are to a certain extent contingent upon how the other party, how the user has acted. In the present case, the notification of infringement was not considered to be problematic, because the court said at the latest when the lawsuit was filed, you had a sufficient notification of infringement. Now here we need to take this specific, let's say, particularities of this case into consideration, because as we've seen, we had a lawsuit being filed and we didn't really see that there was a notification made before the lawsuit was filed in 2019. So this was nothing that the court had expressly mentioned here. But if you remember, when we started talking about the story behind the case here, we said that this initial lawsuit in 2019, it was filed without claims for injunctive relief. It was only limited to damages and the other associated claims. And the court noted that it was undisputed that this initial lawsuit from 2019 included all the information needed for a notification of infringement. So the court saw in the claim, the statement of claims itself, so the first lawsuit filed in 2019, a notification of infringement, which was made before the actual claims for injunctive relief were added in the proceedings, which, as we said, took place only afterwards, only 1.5 years almost after the initial lawsuit in 2021. So in this sense, the court said that the information was available far before claims for injunctive relief were delivered in the proceedings. The fact that the information was included in a statement of claims that launched proceedings was not considered to be harmful here. Since the question was answered in this way, the court also found that there is no need to refer any questions regarding the notification of infringement to the CGU, because it was pretty clear that such a notification had been made here before we had claims for injunctive relief asserted in trial. And the question whether a notification duty exists at all has been already answered by the Court of Justice of the EU. So the court saw here no need to refer the questions or to ask the CGU for guidance in that context. So having said that, the court moved then to the issue of willingness, which is, let's say, the expectation that the CGU has set up in his Huawei ZTE judgment, that an implementer who has received, a user who has received a notification of infringement shall respond and shall express willingness to obtain a license. In these proceedings here, this was a very central aspect, because the courts that had decided the case before, the district court and the high district court, had basically accepted that HMD was an unwilling user. So it had not sufficiently demonstrated willingness to obtain a license, and this was a major reason why the injunctions and the courts had found in favor of VoiceAge in these proceedings. Now, in the appeal stage here, the question that was posed was whether this finding that HMD had been unwilling was correct, without prior examining whether the offers that VoiceAge had done were front in every aspect. The answer of the Federal Court of Justice to this question was that it was not an error, so that the courts could reach or could make this finding that HMD has been unwilling without examining the patent owner's offer in every aspect, or without establishing that the patent owner's offers were front in every aspect. And this is an important question here because it is linked to the very notion of how the Huawei ZTE framework operates. And there is basically a view which had been supported by the European Commission in the present proceedings in the amicus curiae interventions, which says that you should follow a strict sequence of these duties in sense of ticking the box, looking whether the first duty was done. Then if you would accept that this is the case, then going to the second one, and then if you would accept that this was also fulfilled, then move to the third one. The consequence of that would be that if you would say that there is a sufficient notification of infringement, then you would just look whether has been a reaction of the implementer, of the user to that. And after you've clicked also this box, you would then expect to see what offer has been done by the patent owner and examine if the offer was front or not. And then if you would also tick the box there, move over to the further duties of the parties, especially the further duties of the patent user. Now, the Federal Court of Justice did not follow this approach. It said that the Huawei ZTE framework does not establish a mandatory strict sequence of procedural steps, meaning that the Huawei ZTE framework and the mutual obligations of the parties that are being established there should be treated in a more flexible manner. The court focused again on the negotiations and the good faith negotiations by saying that the duties under the Huawei ZTE framework aim at facilitating license negotiations, in which, on the one hand, the patent owner cannot abusively impose excessive prices or discriminatory conditions, but on the other hand, the user should not be allowed to neutralize patent owner's effort to sign a license through delaying tactics. And if you look at that, and if you focus on the negotiations, the consequence, according to the Federal Court of Justice, is that it is not wrong to consider willingness on the implementer's side, on the user side, as a form of permanent condition or continued act. Meaning that, consequently, if you focus on the negotiation aspect and that the Huawei ZTE framework wants to facilitate license negotiations, you should also look at willingness as a continuous request, a continuous willingness, which includes, of course, a continuous request to get a license, but also the willingness to engage in negotiations in a way that moves negotiations further and leads to the conclusion of an agreement. In this context, the court highlighted particularly that delays, especially in the SEP framework and the front framework, in resolving this conflict of interest, in basically signing license agreements, favor the users, in contrast, for example, with supply agreements. And this is why the court, as we're going to see in further on, laid also a focus on delaying tactics and delaying tactics applied by HMD in the present proceedings. Having said that, the court also said that if you want to assess whether an offer that has been made is front or not, you cannot do that in an abstract manner, neither in trial nor before. So you need to consider the parties' behavior in the negotiations if you want also to assess whether an offer or terms, specific terms, contract terms, are front or not. Again, the reason is that Regularly is needed that the parties engage in negotiations and that each party raises points of concern that could trigger further discussions in the negotiations phase in due course. The court said here, you should also be aware that the patent owner will usually not be in a position to unilaterally form a front offer without considering and knowing users' interests. For example, for determining fees that are non-discriminatory, the user's concrete circumstances are decisive in the eyes of the court. Questions like in which markets does the user operate and in which extent, or in which pricing segment the user's products are sold, especially compared to existing licensees of the patent owner, or what is the user's market share, or how is the user's financial standing. So all of this needs to be or is helpful for the patent owner to be able to form a front offer. This means also that when an offer is made, which includes then sufficient explanation of the royalty calculation is delivered as required by Huawei ZTE, then the Federal Court of Justice pointed out that the user must deal with the offer, so he cannot leave the offer aside and don't care about that, and it must deal with the offer in a manner demonstrating his will to reach a mutually acceptable outcome swiftly. This duty is triggered even if the offer is not front in every aspect. Because, of course, if an offer would be front in every aspect, you would not have not enough room for negotiations anymore. So the court, I think, wanted to make clear here that even if there are things that need to be improved, that need to be changed, this does not exclude the user from the duty to negotiate, to engage with the patent owner. The consequence of that, again, would be that a finding of unwillingness by the court derived from the user's conduct after receipt of an offer can be done even if the court has not fully established that the offer of the patent owner was front first. So the court does not need to examine the offer first, find that it's perfectly front, and then basically find that the patent owner has been unwilling because it did not accept this front offer. It's about the process of the negotiations, not so much about the outcome. The court explained that even further. It said if you would require the user to react only after you would have confirmed patent owner's offer as front in every aspect in a proceedings, this could lead to an unworkable situation. And this would apply particularly for portfolios that expand beyond Germany, more international portfolios. Because in these cases where you have bigger portfolios, international portfolios, it would be practically impossible to examine essentiality, validity, and infringement on a portfolio basis in trial within any reasonable time, which of course would also mean that the court would not be able to decide about the front defense in a reasonable time, but this decision would be delayed indeed for an unforeseeable time, according to the court here. And at the end of the day, also from a more practical perspective, the Federal Court of Justice mentioned here that all the efforts needed in trial for a comprehensive judicial assessment of patent owner's offer do not seem justified when the implementer has either demonstrated that its initial declaration of willingness was just mere lip service, meaning not seriously meant, or he's no longer willing. So again, the court placed importance here or placed weight on the process of the negotiations. With all of these principles in mind, the conclusion was, and this insofar the court confirmed the decisions of the district court and the high district court, that HMD was unwilling. Focus was placed particularly on delays, on delaying tactics, as I mentioned before. So the court mentioned here the fact that the reaction to the first license offer received took approximately 5 months. and that HMD needed more than 3 months to respond to amended subsequent offers of VoiceAge. The court also criticized the time needed to react to a draft NDA that had been produced by VoiceAge, approximately 8 months. It took HMD approximately 8 months to respond to that. In the eyes of the court, a willing user should have an interest in concluding an NDA swiftly. So this was not something the court found to be reasonable here. And what the court also mentioned is the fact that during the negotiations, HMD had changed its preferences with respect to the royalty calculation method. So they had preferred a lump sum deal. When they got such an offer, they then said, well, we would like to have a running royalty. So these were all the facts or the part of the behavior of HMD which the court considered or confirmed here as an indication of lack of willingness. Now, having said that, the other question that was open here was, do we need to ask the Court of Justice of the EU regarding the interpretation and whether we see things correctly, whether this type of analysis of Huawei ZTE and the duties under Huawei ZTE is correct? This was something that, as we said before, the Commission really supported in its amicus curiae intervention. But the Federal Court of Justice found that a referral is not needed also regarding this aspect, because in the eyes of the Federal Court of Justice, there are no reasonable doubts regarding the interpretation of union law, especially here, of course, the Huawei ZTE judgment and Article 102 of the TFEU in the present case. The court stressed here that the national courts examine Huawei ZTE according to their own procedural law under consideration of the principles of effectiveness and equivalence. And the court also did not see any obligation, as we mentioned already, to follow a strict sequence of duties irrespective of the circumstances of the individual case. But maybe what was the more important argument here to say that a referral to the CJEU was not needed is that the court believed that this approach taken here, this more flexible approach towards the Huawei ZTE framework, has been followed also by other courts in Europe. So there is no real conflict between jurisdictions in Europe or on the interpretation of the Huawei ZTE framework. The court mentioned, for example, here Dutch courts, the Gerechtshof Den Haag, for example, that had also taken the same approach. It mentioned the UPC local divisions in Mannheim and Munich, and even the UK Supreme Court. This was before Brexit, a decision delivered there in the Unwired Planet case, where the court had also taken a more flexible approach towards the Huawei ZTE framework. So for all these reasons, the court found that there was no referral to the CJEU needed regarding this specific aspect either. Having said that, the court moved then to the security duty that we mentioned before. Very briefly here, the Huawei ZTE framework requires from an user who has received an offer and decided to reject the offer and has made a counteroffer which again was rejected, to provide security. This duty here, according to the Federal Court of Justice, providing security can, of course, on the one hand, fulfill this obligation under Huawei ZTE that the Court of Justice of the EU clearly established there, but it can also be a suitable way for demonstrating serious willingness to obtain a front license. So here the court again applied a more flexible approach by saying that if there is sufficient security placed, this can have an impact on the assessment of the willingness of the implementer. So there is no silos again here, as it is not with the offer of the patent owner. It's also the security payment can be a factor that can indicate willingness to obtain a license on the side of the user, of the implementer. What the court said, however, here is that this duty to provide security cannot go so far as to require the user to make payments to the patent owner, so long as it is unclear whether under which conditions a license will be in place. So the security payment is a security payment, and it's not, let's say, a final licensing payment. This is a reference to the court here to some German case law that suggested that at least to a certain extent, if there is an undisputed party, you could have also an obligation to make actual payments to the patent owner. But the court said here this cannot be required. So you cannot have payments. Of course, however, this does not change the fact that it is reasonable to require the user to demonstrate willingness by placing the security, because this would safeguard patent owner's claims. And not only that, the court said that this duty is important because it also ensures that the unlicensed user has no undue advantage towards licensed market participants or market competitors, which have signed licenses and now are obliged contractually to pay royalties. In this sense, the court also rejected the notion that the duty to provide security puts unreasonable pressure upon the user. Now, when we look from a practical angle on the security payment itself, there are two questions that are very relevant. Timing, one question, of course, when should this security be placed? And the second important practical question, the amount. What should be the amount of the security payment? The Federal Court of Justice answered only one of these questions, the timing question. So it said the security payment must be provided immediately after rejection of the counteroffer. Timing is not in the user's discretion here. So when the security payment shall be paid is not something that the user decides at its own discretion. It should be done immediately after rejection of the counteroffer. What the court clearly disagreed with is the view that a duty to make the payment is triggered only after parties have landed in litigation and after the court has confirmed in litigation that the offer of the patent owner is front in every aspect. So the court said this is the wrong way to read the Huawei ZTE framework. The duty is triggered immediately after the counteroffer is rejected. What should be the amount? The court left this question open because, as we're going to see in a moment, it was pretty clear here that the security placed initially, particularly by HMD, was not enough. So that's why it did not also see a need to refer the question of the amount to the CJEU. It left the question open, and it left also the question open whether the view taken by the Munich Higher District Court that the security payment must basically mirror the patent owner's offer, not the implementer's or the user's counteroffer, but the patent owner's offer, whether this is the right way to go was not decided by the court either here. In the present case, in the eyes of the court, it was clear that HMD did not provide sufficient security. The initial deposit, which was for 10,000 euros, was found to be not even close to the amount corresponding to HMD's own counteroffer. And the fact that this amount was then raised, as we've seen in the beginning, was also not found sufficient. Here, not so much due to the amount, but due to the timing, because this amount, the additional amount of security, was provided by HMD only after the end of the oral hearing in the appeal proceedings, which was more than 3 years after the counteroffer. So having said that, the court also then turned to the last issue that we want to discuss here today, the proportionality. The court dealt with this issue because there are some discussions also in the case law of the district courts in Germany, but also in the higher district courts level, of how to deal with proportionality in the SEP and front context. When we talk about proportionality in German case law, or also maybe European case law, we are talking about the notion that an injunction should be limited in cases in which the effects of an injunction would be disproportionate or cause disproportionate harm or hardships to the infringer. Although you have an infringement, you should not grant an injunction or limit an injunction because granting an injunction or enforcing an injunction would cause disproportionate harm. So this is the, let's say, the basic idea behind that. In Germany, we have, after the 2021 Patent Act reform, also a specific provision in the law in Article 139 of the German Patent Act introduced, which mirrors case law of the Federal Court of Justice regarding these questions before. So here the question was, did the courts previously err in finding that in the present case, an injunction should not be limited based on proportionality? So that was what the courts had decided before. Is this correct? Was this the correct way to go or not? And here the Federal Court of Justice clearly said that there was no error in refusing to limit injunctions here in the present case based on proportionality considerations. The court stressed that injunctive relief is the regular remedy against infringement. So any limitation is thinkable only in exceptional cases. And the question is, can these exceptional cases be there? Can they occur when we have front cases in which the court finds that the user who is facing an injunction had been unwilling, as it was the case here? And the court clearly said that in cases in which you have a user who is infringing, but nevertheless demonstrates lack of willingness to obtain a license, then this user regularly cannot assert that an injunction would cause unjustified hardships in terms of the provision I mentioned before of the German Patent Act, which would then require the injunction to be limited. Interestingly here, to put some context, the court mentioned that you should look at the interests again of the parties, because on the one hand, you have a user that has a claim to be allowed to use the patent on front terms. But on the other hand, you have the patent owner that has not a respective claim to require the user to conclude a license agreement. So in this scenario, when the user is unwilling, then it is difficult to refuse an injunction for the patent owner because, again, he has not the possibility to force the signing of an agreement. And on the other hand, referring the patent owner, to damage claims is not sufficient in this context. So that's what you should also consider when you're talking about proportionality in the context of SEPs and front committed patents. Here in the present case, there was some argument whether proportionality would mean that the injunction should be limited, and whether proportionality, or let's say the disproportionate character of an injunction, would be sufficiently based on the fact that VoiceAge is what was called here a pure patent monetization entity. This is an argument basically saying that the interest of a patent owner who does not itself use the teachings of the patent that's being asserted, let's say, to protect own products in the market against its competitors, should have limited access to injunction, or even no access to injunction. But the court said here, the fact that the patent owner does not use the patent it holds itself does not per se lead to the exclusion of an injunction. The factor that was far more important in the eyes of the court here when it comes to proportionality was the fact that HMD had applied delaying tactics and had also indicated its unwillingness to obtain a license. The final point, which I think is also interesting, is the court's thinking behind what would be potential hardships here if you grant an injunction. And insofar, the court went back to HMD's own pleadings in the proceedings and noted that HMD had basically suggested that they had managed to get a workaround, and since February 2022, they were in a position to sell products in the market without implementing the patent suit. So here the court said, even if you would consider that, you could not see any disproportionate hardships because the injunction would not exclude products that are not infringing the patent suit from the market. So this was also a limitation. There was another argument regarding potential harm from an injunction by arguing that if you would grant an injunction, then you would make it difficult for VoiceAge for HMD to sell its patents to sell its products in the market because certain operators do not want to sell patents products that are not standard compliance or non-standard compliance phones. But the court did not go into the details of these arguments by saying that HMD had been unwilling here, which was, let's say, the most important factor to consider. The final question here was, did we need a referral to the CGU regarding this question, the applicability of the proportionality principle in SEP cases? And here the court had the same conclusion. It said no, a referral is not needed, basically because in the proceedings there were no pleadings or no indication that the German Patent Act, the relevant provision I mentioned before, Article 139, paragraph 1 of the Patent Act, is not in line with EU law. And especially the court mentioned here the IP Enforcement Directive. So also in that respect, the court did not see any reason why the CGU should be involved with these topics or with these questions that have been decided in these proceedings.